Well, we've come to our keynote presentation of the luncheon program. Our keynote speaker is Bill Rochelle. He's a bankruptcy columnist and editor-at-large for Bloomberg News in New York. Before joining Bloomberg in 2007, Bill was a bankruptcy lawyer for 35 years, the last 17 as a partner in the New York office of Fulbright and Jaworski. In his column for Bloomberg, Bill covers upwards of 20 companies a day, reporting developments in pending Chapter 11 cases and identifying businesses that might end up in reorganization. Bill also has a weekly video. He received his undergraduate and law degrees from Columbia University, where he was a Harlan Fiske Stone Scholar at the law school. Bill appears frequently as a commentator on Bloomberg Radio and TV. So please help me in welcoming our keynote speaker today, Bill Rochelle.
Well, it's a great pleasure to be here today, although I must tell you, when I found that I was going to be following Jay Crystal, the first thought in my mind was, well, actually, I should be opening for him. My second thought was to withdraw, because there's no way anybody can follow Jay Crystal, especially when what I have here is about 50 pages of prepared material that I intend to read verbatim. Ergo, anyone who wishes to, you can either fall asleep right now or leave before boredom sets in altogether, because I guarantee you it will by the time we're through. As I look out across the room, I haven't seen so many judges together in one place since the last time the 5th or the 9th circuits sat en banc. The difference is, you judges, you bankruptcy judges, have more in common and have better feeling about one another than I think is typical on the circuit benches. When I was given this opportunity to come and speak to the NCBJ, I jumped on that chance for two reasons. First of all, there is nowhere else on earth I could go, spend 4 days, and never spend a nickel for food or drink. Indeed, it seems to me that the more the bankruptcy business declines, the more the turnaround managers give parties trying to cling on to market share. I've got to tell you before I get into my discussion about some case law that I am sad to say I see no quick turnaround in the bankruptcy market. However, rest assured that the seeds of the next debacle already have been sown, and indeed, there are bubbles under our very noses. Right now, the government and the corporate debt market looks like the prior housing market in terms of bubble, like housing was nothing at all. And of course, this new bubble, or bubbles, because I think it's plural this time, is being brought to us by our friends at the Federal Reserve. Like with housing, so long as everybody is fat, happy on Wall Street, making lots of money, they are going to stick by their policies until something explodes that's beyond their control. I also enjoy being here at the NCBJ even more now because I am no longer a practicing lawyer. That means I can come to this gathering and not have to prevaricate about how busy I am. This does not mean, however, that my job is without its pressures. Because if I happen to make a mistake in my daily column on Bloomberg, thousands of people are going to read it, and I will certainly hear about it. And actually, how I was hired to work for Bloomberg is an interesting story in itself. In my last approximately 10 years at Fulbright, I had a daily newsletter I sent to clients that described what was going on in the major bankruptcies around the country. I got to know a whole bunch of bankruptcy journalists as a result, and eventually got invited to come to the office of Bloomberg in New York to have a meeting with the chap who headed, or still heads, the whole news division, because he wanted me to give some ideas about Bloomberg's bankruptcy coverage and how it was done well and how it could be done better. Turns out he had read my column before I came, and after I had been talking with him for less than 10 minutes, he offered me a job right out of the blue. I'm not sure what happened next because I had immediate heart failure. On the way home that afternoon, as I was walking home, I was thinking about my life. I said, I have 2 houses, I have 2 cars, I have 2 kids, I have 2 dogs, and I've had 2 wives. So it occurred to me that there was really nothing more that I needed. And in fact, if I continued working hard as a lawyer, I was doing nothing except generating some estate for my good-for-nothing, snotty-nosed kids. As a consequence, I decided to go work for Bloomberg. And I invite any of you who are in New York to send me a message and come by and visit the office. It is really unlike anything you will have ever seen anywhere. It is pretty much a combination of a trading room floor and Starship Enterprise. When you come to Bloomberg, you will enter on the 6th floor, which is this huge wraparound food court. And as we stand there together, you'll be able to look out at the Bloomberg workers and be able to tell exactly what their job is by how they're dressed. Let's first imagine that you see somebody wearing cut-off blue jeans, flip-flops, walking around like she's been up all night. That, of course, is a software developer. Next, assume you see man or a woman, immaculately dressed, blue suit, gray suit, white shirt, white blouse, perfectly coiffed hair, gorgeous, handsome, tall, charming. That, of course, is someone in sales. Finally, assume you see somebody with badly out-of-date clothes that are a bit rumpled in any event. Probably this person will be walking around carrying either a novel or a book of poetry. I guarantee you that is a journalist. The reason is, journalism is the resort of English majors who don't sell out like us lawyers. And frankly, that's what I did. I went to college, immediately sold out, went to law school, immediately sold out, and went to a Wall Street firm. My brother took a somewhat different track. You see, my brother, he's the smart one in the family. He went to a very fine undergraduate school. Then he went to Oxford to work on a PhD in English. It was while at Oxford he decided to sell out and go to law school. In any event, I owe a great deal to my brother for many of my speaking engagements, because very often what happens is like this. The program committee will talk about whom to invite, and somebody in the group knows that my brother is a great storyteller. Because in our family, my brother got the genes for intelligence, and he got the genes for humor and storytelling. All I got was genes for hair. So the program committee will talk about who to invite, and they'll say, well, tell you what, let's invite Rochelle because he's a great humorist. They all agree, and then the program chairman goes back to his office, opens up his email, types in for the name Rochelle, clicks on the first name that comes up, sends off the message. And I have learned immediately to accept these invitations before they realized they were trying to invite Buzz. Because you see, Bill comes before Buzz in alphabetical order. When I'm given a speech, Bloomberg gives a great deal of support to its personnel for our public speaking engagements because, believe it or not, we have an in-house comedian who will help us with our material. So I went to him and I said, listen, can you please give me some jokes that won't offend anybody? And he said, can't do it. The nature of humor is every joke has got to offend somebody. So I said, okay, well, listen, can you nonetheless give me a joke about bankruptcy? He said, can't do that. Nothing funny about bankruptcy. Obviously, this man has not read the latest bankruptcy opinions from the courts of appeal. And this is what I'm going to talk about today, is the last year's important opinions from our courts of appeal and other appellate courts. Those of you who are Bloomberg customers, you have a terminal or you have B-Law or you receive the, what do we call it, the Bloomberg Daily Bankruptcy and Reorganization Brief. If you've read these things, you can leave already, because I'm not going to say anything that I haven't either said or hinted to in my writings over the last year. Where I think, of course, we have to begin is with our Supreme Court and with the two cases they are going to consider this year on issues of bankruptcy law. Now, naturally, everybody believes that the follow-on case on Stern versus Marshall, that's called Executive Benefits versus Arkinson, is the most important decision on bankruptcy to come down this year. I will beg to differ, as I will explain in a minute. But for right now, let's talk about executive benefits and what it means, or better yet, what it may mean in the future. The issue, of course, with executive benefits is whether or not Stern rights can be waived. Now, my own view is this opinion is going to result in a ruling that it is not waivable. Now, that is not based upon my own view of Supreme Court precedent, not at all. It's based almost entirely on what I saw among the justices when I observed the argument on Stern versus Marshall itself a couple of years ago. One of the advantages of being a journalist is that I get to sit in the reporter section of the Supreme Court right at the side of the bench, and so you get a really good view of the justices and their expressions and everything else. Something that really struck me during that oral argument was how the justices, to a man and a woman, were very concerned about preserving the prerogatives of the Article III judges. That, despite the fact that the decision, of course, was 5-4. And I suspect that that point of view is going to greatly inform the next decision, because I believe the Supreme Court, unlike perhaps lower courts who are very busy, believe that if you give the executive an inch, it's going to take a mile. And so they are protecting their prerogatives. Now, I've got to say that, of course, there are a lot of folks who believe that the court is going to rule that Stern rights are waivable. Prominent among them is Eric. Yes, thank you. Oh, boy, he's going to kill me for this. Last time he's ever going to give me a quote for an article. Brunstad, of course, is the lawyer who argued Stern versus Marshall and won the thing. But he is of the view that Stern rights are perfectly waivable. He equates them to rights to a jury trial. Well, beyond who wins and loses, I think this case decision isn't going to make much difference one way or the other. However, as I'm going to try to explain in a minute, I think the next case, 2 or 3 years from now, will be a whopper. So let's look at what can happen. If the Supreme Court says that Stern rights are waivable, no biggie, obviously we're under the same burdens we already got, no big deal, life goes on. Let us assume that they rule instead that Stern rights are not waivable. The case before the court right now involves situations in which the Stern question was raised on appeal, So I think the holding is only going to deal with the ability to waive Stern rights while a case is still pending. However, what about the next case? What about situations in which Stern rights are waived long after the bankruptcy court opinion is beyond any time for appeal? That's a different kettle of fish. In that regard, District Judge Jed Rakoff in New York has said something pretty darned important, and believe me, Jed Rakoff is no Humpty Dump. He is a brilliant man, a senior judge, and he sits often on the Court of Appeals for the Second Circuit by designation. At any rate, Judge Rakoff said that bankruptcy court decisions within the ambit of Stern versus Marshall are not entitled to, get this, res judicata or collateral estoppel effect. Now, let's assume he's right. What does this mean about the value of a bankruptcy court decision, let's say years after it's been written? I frankly don't think it has any bearing beyond that particular dispute that's already decided among those two parties. I frankly think that it's worth not anything more, perhaps even less, than a federal agency decision. This is why I think it's not this case, but it's the next case that is really going to define what the powers of our bankruptcy judges are. And also, by the way, of course, I think this decision is likely as not going to tell us whether the federal magistrate system is dead as a doornail. The Fifth Circuit, as you may know, already wrote an opinion where they pretty much hinted, if not almost flatly said, that the federal magistrate system, as we know it now, is unconstitutional. Let's go on to the next case, Law versus Siegel. If you think that it only has to do with individuals, well, I'm not so sure that's correct. As we're going to see in the next few minutes, there is a theme in recent appellate decisions on bankruptcy having to do with whether or not, really as a result of the plain meaning rule, there is now gigantic limitations on the equity powers of federal courts. Let's see what Law versus Siegel is all about. This was a case where there's obviously a split among the courts of appeal, and the court in San Francisco, the Ninth Circuit, held that a bankruptcy court had power to take away exempt property to, shall we say, make up for a fraudulent transfer that could no longer be recovered. Big deal. Remember I said take away exempt property. Statute says explicitly it's exempt, the trustee can't touch it, but the Supreme Court said you could. The Ninth Circuit said you could. In reviewing this case, I think the Supreme Court could approach the case really in maybe two different ways. Number one, they could use a microscope and look at the federal bankruptcy code and see if there is a way under Section 105 or God knows what. Oh, how delightful. This is going to make it difficult to read my prepared notes.
It is Halloween.
Well, let me continue for a moment in any event until somebody figures out where the lights are. Actually, it's going to enable those of you who wish to fall asleep much more quickly. And I won't hold it against you.
Do you need a light?
How about that? Got a light. Going right ahead, the other way the Supreme Court could look at the issue is a bit more broadly and decide whether or not bankruptcy courts have roving equitable powers to bring about results that they believe are just in the circumstances. For me, I think this could be a blockbuster case, absolutely blockbuster case, on whether federal courts can use equitable powers to override what otherwise appears to be the plain mandate of the statute. As I said a few minutes ago, this could be an era in which the plain meaning rule is going to start severely limiting the equitable powers of courts. This essentially is a question or a case for the Supreme Court that I believe is the turning point on equity. If the court says there is no equity in this circumstance, then methinks we are going to have a rather thoroughgoing re-examination of the equity powers of federal courts when they come into conflict with a statute. And by the way, I think the law case, depending upon how it comes down, could also have a great deal to say about what we call gift plans in Chapter 11. And I think most of you know what gift plans are. Those are circumstances in which a creditors committee sues a secured creditor, and then the secured creditor settles by contributing money to a trust for unsecured creditors, bypassing the priority system in federal bankruptcy law. In other words, unsecured creditors under these gift plans can receive something that steps over the bankruptcy priority system. If the law decision comes down and says, no, you have to follow the statute, I think if we combine that decision along with the Radlax decision from, I believe it was May of 2012, then I think you're beginning to put together some pretty persuasive authority for the notion that gift plans are simply not going to work. Further looking at some of the cases where we have conflict of interest, it's not conflict of interest, conflict of circuits, excuse me. I was really shocked when I was preparing these materials. Oh, let there be light. I read every bankruptcy appellate decision that comes down typically within 24 hours of when they're published. And I write them up immediately if they are of any significance at all. And I was surprised when I went back to review my materials that in the last year alone, not outstanding right now altogether, but in the last year alone, there have been 10, count them 10, splits of circuits. That is a lot. The first is a split that will not be resolved because earlier this year, the Supreme Court denied certiorari in the Charter Communications case. That would have been a decision that would have told our courts whether, and this is a biggie, the doctrine of equitable mootness can be employed to dismiss an appeal when the statute otherwise gives a right of appeal. Further, the courts are split on whether or not, even if there is a valid doctrine of equitable mootness, that the standard for review is either de novo or abuse of discretion. This is a biggie, which I think will eventually come back to the Supreme Court, because again, as I said before, this has to do with equitable powers. Can the courts, in their equity bench, invent a rule like mootness to destroy a right of appeal that Congress otherwise has given? So that is number one, but we hardly stop there. The next case is one that, God bless him, was really initiated by Mike Lynn, bankruptcy judge in Fort Worth. Mike is one of my two best friends on earth. One of my other best friends on earth either is or used to be John Olson, sitting right there. John and I have been friends since we both came out of different law schools together and worked together forever. Yes, thank you. We do have the lights on. In any event, I've been sort of leery about hanging out with John much recently since he started holding people in contempt willy-nilly. In fact, Eric Brunstad, about whom I just spoke, has called him the great incarcerator. I don't know what there is about Florida and Nevada, but that seems to be the two hotbeds for improper activities by counsel. In any event, let's go back to Mike Lynn. He importuned, or he held, that artificial impairment is no bar to confirmation of a cram-down plan. And this is a holding that was adopted by the Fifth Circuit by Circuit Judge Higginbotham in a case called Village at Camp Bowie. This is an important decision on artificial impairment. We have, let's see, what is it? We have the Fifth Circuit and the Ninth Circuit allowing artificial impairment, while on the other hand, the Eighth Circuit does not. If there's ever a case I thought was important for the Supreme Court, that is it. Next, let's go on to an individual kind of a case, which is nonetheless, I think, important for Chapter 11. And that comes out of the Sixth Circuit. And the question is denial of confirmation interlocutory or is it appealable? As I said, these cases typically arise in Chapter 13, but I frankly see no reason why the same can't be done in Chapter 11 when a debtor's plan is turned down. Is it or is it not interlocutory? And on that one, the courts are split 5-3 in favor of interlocutory. Next, let's go to Chicago, the Seventh Circuit. Circuit Judge Easterbrook. Interesting case, are inherited IRAs exempt? This is another case has to do, I think, as much as anything, with equity. The Fifth Circuit, by contrast, in a decision by Judge Stewart, said that the court is constrained by the plain language of the statute, and therefore inherited IRAs are exempt property, just like an IRA you can create with your own contributions. Judge Easterbrook didn't buy it at all. His decision for the Seventh Circuit found that it is not an exempt asset, and his decision is really a classic invocation of the Chicago School of Economics theory applied in bankruptcy. This is another marvelous case that is going to tell us, if it ever goes to the Supreme Court, whether economic theory or the plain language of the statute carries the day. Let's go on to yet something else. Again, the Ninth Circuit, which frankly seems to be the circuit that creates most of the consternation these days, and are very interesting cases of split of circuits. This is a case in which we have the Ninth and the Fifth Circuit on one side and the Sixth Circuit on the other. Here, the question is, and again, another case on equity, may bankruptcy courts recharacterize debt as equity only under state law and not under general equitable powers? This is another one I think is a real biggie. Are the courts, now under the era of plain meaning, going to be placing restrictions themselves on their equity powers? It doesn't, I think, get any more fundamental than that in terms of the powers of Article III courts, if suddenly their equitable powers are taken away, perhaps by implication, by vague federal statutes. Now, as I said, the Supreme Court is really hung up on the question of the prerogatives of the federal judiciary. And that's where I think we're going to have very interesting decisions when, if the court ever takes these cases, to tell us, does equity powers survive plain meaning? Well, the first thing that came to my mind along those lines is, which is the older doctrine? And frankly, it seems to me that equitable powers of courts, which we adopted from Britain, is really a much more venerable doctrine than that of plain meaning. Let's go again to the Ninth Circuit in a case called Aquin versus County of Kauai. And by the way, I keep forgetting to give the names of these cases. If you're ever interested, and probably nobody is, but if you're interested in what the names of the sites of the cases were, come and catch me later or send me an email and I'll tell you. In any event, back to the Ninth Circuit. This is a case involving equitable estoppel and whether or not, or what the standard is for employing equitable estoppel. Now, because I read all district court opinions on bankruptcy that come down, you would be shocked, absolutely shocked to know that somewhere in the neighborhood of 30% of all district court opinions have to do with equitable estoppel. That is to say, it's a situation in which a bankrupt, either former or present, files a lawsuit but had not listed that lawsuit among the assets. The amount of litigation on this is absolutely staggering. So this is an important decision because the Ninth Circuit held that the presumption of deceit, very important, does not apply if the bankrupt reopened the bankruptcy case to list the lawsuit as part of the property. As important as this is, or it is important for the administration of bankruptcy laws, I think it is a case that ought to be worked out among the circuit courts and eventually by the Supreme Court. Next, oh, and I love this, Lubrizol. You all remember Lubrizol? Such a great name. This was, if I recall correctly, 1985 Fourth Circuit. The case there was on the question of whether, if a debtor rejected an executory trademark license, did that thereby bar the licensee from thereafter using the trademark. The first case that was really quite important this last year came again from the Seventh Circuit. This came from Judge Easterbrook. Cert, by the way, was denied early this year in this case, which was called Sunbeam Products. Judge Easterbrook, I think, took the absolutely correct approach. He said, well, what happens with a trademark outside of bankruptcy if the licensor breaches the contract? He said, because after all, rejection is nothing more than court-authorized breach of a license. He said, outside of bankruptcy court, the licensor's breach does not take the license or the use of the license away from the licensee. And he said the same thing has got to apply in bankruptcy. Well, guess what? The same issue came up in the Eighth Circuit, and in a split decision 2-1, they held the other way around. They joined with the Third Circuit in Philadelphia and said that yes, indeed, if you reject the trademark license, it rips away the license from the licensee. There was a petition for rehearing en banc, and the petition was granted. It looked for a while that this case might not actually be decided in the Eighth Circuit because the appellee was none other than Hostess, the now re-bankrupt maker of Wonder Bread. Hostess was the one who had granted or who had terminated the license in the first bankruptcy. It shows you how long disputes stay alive in bankruptcy, as of course we all know. Hostess came to the circuit court and said, listen here, we don't frankly care what happens. We are completely liquidated. It will not make any difference to us one way or the other what happens with this license, so please dismiss this appeal as moot. Well, the response from the Eighth Circuit was a bit like that famous line from Gone with the Wind, where the court said, frankly, my dear, I don't give a damn. And they told Hostess to go ahead and to brief the issue. That will be decided in upcoming months, and I really hope, that this is the final breath of life in Lubrizol, and perhaps, and I guess it's going to take the Supreme Court to fix the issue, but I suppose it's going to go up. Now then, let's move on to the 11th Circuit. All of you Florida judges' favorite circuit. I don't think we've talked about them too much so far, but they are on the prevailing side here. They have lined up with the 3rd, the 2nd against the 8th Circuit. And this is a really interesting case on dismissal of a Chapter 7 for bad faith conduct that occurred before bankruptcy. The 11th Circuit is among those who says that yes, bad faith conduct before bankruptcy is grounds for dismissal. I must say that holding creates a bit of turmoil in my gut. It seemed to have been emanating from the notion that bankruptcy is for the benefit of the debtor. Well, that's partially true for an honest debtor who can get a discharge. But also bankruptcy is for the benefit of the creditor, and especially so the small creditors who don't have the wherewithal, the inclination, or the ability to protect themselves. So if you allow a large creditor to raise issues of pre-bankruptcy good faith and dismiss the case, guess what? You've just done a mitzvah for the large creditor, but guess what? You've hurt the small creditors. It just strikes me that bankruptcy is chock full of all kinds of remedies to be able to deal with a debtor who had inequitable conduct before bankruptcy. But it doesn't strike me that dismissal of the case is the way to go. That, as you can guess, is a case, I hope, one day, goes to the Supreme Court. Let us move right on. Again, to a more of an individual case, but one I think that comes up very often, because believe me, there is a huge amount of litigation brought by bankrupts under the Federal Fair Debt Collection Practices Act. That is the statute that you can use when a lender has used improper methods banned by Congress to try to collect a debt. The courts are now split and I mean the circuit courts, are split 2-2 on this particular question. And the question is, does the bankruptcy code preempt the FDCPA and therefore preclude bankrupts from bringing lawsuits for unfair debt collection practices? We have an even split of circuits right now. We have the 7th and the 9th on one side, the 2nd and the 9th on one side against the 7th and the 3rd on the other side. I frankly, if I can be on my soapbox a little bit, don't know why the remedies of the two statutes, bankruptcy and the FDCPA, cannot be cumulative. There is, however, out there, and you may not see it too much in bankruptcy court, but when you get to the district and the circuit level, there is very often a real antipathy to lawsuits by bankrupts. And if you don't believe me, come talk to me and I'll tell you some jot and tittle about some of the judges who I think have that view. Next, let's go on to Louisiana, because there, District Judge James Brady joined in a conflict of circuits having to do with garnishment, wage garnishment. This is something I think you judges out there in particular can use, and also Chapter 13 and Chapter 7 trustees. What Judge Brady said was that if wages are garnished, and by that I mean actually taken by the creditor within 90 days of bankruptcy, he said that's a preference. The courts are split. The 6th Circuit takes the same view. The 2nd and the 11th and the 7th take the opposite view. What is interesting about Judge Brady's decision, and believe me, it is a brilliant, brilliant decision, he said that every other court to consider the issue has not given account for Section 547E3 of the Bankruptcy Code. Ergo, folks, I think that is a case that is extremely important in the administration of bankruptcy law. Next, I would like to mention a few cases in the wake of Stern versus Marshall and on the issue of jurisdiction that is really very important. These are not necessarily circuit split cases. The first is actually the 7th Circuit's case that was decided after cert was granted in executive benefits. It's a wonderful decision. You really ought to read it, by Circuit Judge Tender on the 7th Circuit. He, of course, concluded that Stern rights cannot be waived, but that's not what I want to talk about now. He said, and get this, because this is really important in the 7th Circuit, if Stern rights are not waivable. He said that if a core issue falls within Stern's ambit, there must be immediate withdrawal of the reference. Let me say that again. If it is defined in the statute as core, but it falls under Stern, withdrawal of the reference is mandatory and immediate. He said that's because the statute gives a bankruptcy court no right to issue proposed findings in a core matter. That is a biggie, and that is the kind of an issue that we're going to be deviled with for the rest of my lifetime, and yours perhaps as well. There's something amusing about Judge Tender's decision. He had to explain why he was going to go ahead and decide the waiver case when the Supreme Court had already granted certiorari. He said, well, that's because the issue is sufficiently clear. But then he needed 60 pages to explain why it was so cotton-picking clear. Otherwise, I think the 7th Circuit has done some great work in the last year. Let's move back to Judge Rakoff in New York. This is an important line of cases of his. Most of these are in the Madoff case. Judge Rakoff held that withdrawal of the reference is mandatory even on settled issues of non-bankruptcy law, so long as the underlying case is complex. In other words, my friends, if you are a district judge and you frankly don't trust the bankruptcy judge, you can use his decision to withdraw the reference. It is possible that District Judge Rakoff has gone a bit too far, but nonetheless, it is with authority hanging out there right now. Let's bounce back to the Fifth Circuit. Boy, howdy. Did they ever have a decision? Wasn't too long ago. It was this month in October in a case called Frazen versus Haynes and Boone. Anybody here? Oh, there's some Hayboot people here, I'm sure. Yeah, you know about this really well. So if I get it wrong, tell me about it. And it's not so much really about this case and who won and who lost. It's really what's going to happen next. Here's the deal. The lawsuit had two main issues. One was stern, one was non-stern. On the non-stern matter, the circuit court, the Fifth Circuit, held that the findings of fact by the bankruptcy judge were not clearly erroneous, and the court therefore upheld the non-stern final judgment in the bankruptcy court. The other issue was within the ambit of stern, and so there was no power, the court said, for the bankruptcy court to issue a final judgment. But here's the hooker. The findings of fact in the non-stern issue were absolutely dispositive of the legal conclusion in the stern issue. So the Fifth Circuit sent the case back to the district judge without frankly telling him what in the hell to do. But this, believe me, is going to be a situation that will come up time and time again. What if you have a case with stern and non-stern issues, the bankruptcy court makes finding on the non-stern issues, is the circuit court, because it affirms the non-stern findings of fact, compelled to follow them, or can the district court make its own findings? Boy, howdy, ain't that fun. Let's go on to, let's see, there is another, oh yeah, out of the Third Circuit. Really important stuff. A Delaware district judge, of all things, had held that the bankruptcy court had no power to reopen a case and interpret the court's own prior decision for use in a state court proceeding. The Third Circuit, God bless their hearts, snapped it up and reversed it, saying that the bankruptcy judge has both the jurisdiction and the discretion to interpret that court's own orders for use in a related state court proceeding. Finally, because I can note that some of you are beginning to nod off here, that there are a couple of cases I ought to mention because I am really not sure that they were correctly decided. First, we have a decision from the Fifth Circuit in a case called Kincaid versus Kincaid. And as you can guess, because the names are the same, it's a follow-on to a matrimonial dispute, albeit in bankruptcy court. Circuit Judge Elrod held that the bankruptcy court has no power to second-guess the matrimonial court about what is or isn't in the nature of support. This is a biggie in the Fifth Circuit because my notion of law always had been that a bankruptcy court had the power to go and re-examine a matrimonial judgment to figure out whether or not indeed it was in the nature of support or division of marital property. Finally, another case that is, well, I'll tell you what, that's enough. You're bored enough. Let me tell you where all of this leads me. I think what this country desperately needs is a federal circuit court of appeals for bankruptcy. The system we have right now has got dozens of conflicts of circuit out there, and that causes all kinds of hell. Number one, it leads to enormous foreign shopping. For instance, When is the last time you ever saw a big case in California? Well, virtually never, because California, or the Ninth Circuit, forbids third-party releases, and the second and third are pretty generous in allowing them. So number one, we have a great deal of foreign shopping. And number two, we have a Supreme Court which is not at all inclined, nor even does it have the time, to resolve these splits of circuit. And frankly, just as well, because I think, other than perhaps Justice Breyer, this stuff is basically above their heads and above the heads of their clerks. If one were to propose having a separate federal circuit, I am sure that both parties would refuse. I mean, the Republican and Democratic parties refuse, because nobody wants to allow new Article III judges to be appointed. God knows it's hard enough just to fill the open judgeships that we have right now. What I think we ought to do is to have this federal circuit for bankruptcy comprised of volunteer judges from the circuits, so we don't have to have any more additional judges. Indeed, it won't create any additional work. In fact, I think it'll make it less. You could get judges like, if she would do it, Carolyn King from the Fifth Circuit to volunteer for service. The result of this, if you had expert judges dealing with bankruptcy, they could per curiam out a lot of these decisions and focus their efforts on the ones that are important. And within a matter of years, we wouldn't have any conflicts of circuit. And frankly, very few cases would have to go to the Supreme Court. So I'm really hoping that within our lifetimes, this gets done so that we have some consistency in our bankruptcy law. Because even though, the last amendments were, 8 years ago, more and more of these conflicts of circuit are beginning to bubble to the surface. And if the Supreme Court takes only 2 a year, they're just going to multiply in number. So that is my modest proposal for the simplification, the beautification of the bankruptcy system. Thank you and good day.